there's one further stage in the process, and this I will get to the end. This view now taken by the Attorney General still required a determination that Iraq was, quote, in further material breach of its obligations. The legal advisors in the FCO considered that only the UN Security Council could make that determination. But the attorney took the view that individual member states could make this determination, and he asked you to provide your assurance that you had so concluded, i.e. you had concluded that Iraq was in further material breach. And on the 15th of March, which is 5 days before the action began, you officially gave the unequivocal view that Iraq is in further material breach of its obligations. So it was on that basis that the attorney was able to give the green light for military action to you, to the armed forces, to the civil service, to the cabinet, and to Parliament. But it remained the case, as Sir Michael Wood made clear in his evidence, that while the Attorney General's constitutional authority was, of course, accepted by the government civil service advisors on international law, headed by Sir Michael Wood, although Miss Wilmshurst herself decided to resign at this point from government service, they accepted his authority, but they did not endorse the position in law which he had taken, and it remains to this day Sir Michael's position. He said this in his witness statement, that, quote, the use of force against Iraq in March 2003 was contrary to international law. Now, my first question is, have I given a fair summary of the legal background?
Yes, I think that is a fair summary of the legal background. I would say, however, just one point, Sir Roderick, which is that what was so important to me about Resolution 1441 was not simply that it declared Saddam in breach, gave him a final opportunity, but it said also in Op 4 that a failure to comply unconditionally and immediately and fully with the inspectors was itself a further material breach. This was extremely important for us to secure in that resolution, and we did secure it. And what we kept out of 1441 was an attempt to ensure that we had to go back for another decision.
I went through that in considerable detail, as you probably saw, with the Attorney General, just to make sure that we clearly understood the different positions and the weight that was being given to evidence received for private conversations and what was said on the public record. So if you will allow me not go over all of that ground again, if you are content with the way that we discussed it with the Attorney General. And I would really move on to my next question, which is that going back to the first half of 2002, which we discussed right at the beginning of today, the period when your strategy was evolving away from containment for the reasons you explained and towards the American position, and therefore you were beginning to discuss the possibility or the contingency of having to use force. In that period of the first half of 2002, when you were having these discussions, did you seek legal advice from the attorney or indeed from anyone else?
We got a paper, I think it was an 8th of March paper, which set out the legal position. And that set it out in the terms that you had just summarized. I was obviously not just very interested in it for obvious reasons, but interested in it for this reason as well, that we had taken action in 1998. And we'd taken action on the basis of the revival of Resolution 678. So it was very important to me because we'd already taken military action, and indeed, as you rightly point out, military action had taken in 1993 as well. But we had that before us, and one of the things that was most important in us going down the UN route was precisely the legal advice that we got.
Yep. So you wanted at that early stage to know the legal parameters. Do you remember where that advice came from? Was it from the Foreign Office's legal advisors, or?
I don't, but I may be able to.
If I put it another way, I think from our discussion with the Attorney General, it didn't come from him, because if I'm not misremembering his evidence, I don't think at that stage he had been consulted.
It came from the Foreign Office, actually.
It came from the Foreign Office. Could you say why, given this is pretty serious territory you were beginning to get onto, you didn't at that stage think it necessary to consult the Attorney General?
I mean, we were, in my view, a long way at that point from taking a decision. Had we come closer to the point of taking a decision, of course, we would have needed to have taken the formal advice of the Attorney General, as indeed we did. At that stage, we had the advice of the Foreign Office, and actually the Foreign Office advice was pretty much in line with what Peter Goldsmith then later advised me.
It was 100% in line,
yeah,
as we understand from both of them. So at that point, building the Attorney General into the process of forming policy, having him at meetings like, say, the meeting at Czech, as you discussed, wasn't something you felt a need to do?
Not at that stage, because we were, as I say, at a very preliminary point. But what I took from the advice that we were given was that we needed a fresh resolution.
Yes.
Right. Yeah.
So that was...
I did point out that, because this was why, at a later stage, I became concerned as to what the legal problem was, because, of course, we got a further resolution.
If I could just stick a little bit for a couple of minutes with the Attorney General's role in this, because his evidence is very fresh in our minds. I mean, in previous governments, it was quite frequently the practice for Attorneys General to attend Cabinet, and indeed in some war cabinets. You didn't have a war cabinet before the conflict began here, but you had groups of advisors who met. Ministers and advisors. Attorney Generals, sometimes in the past, quite frequently in the past, would have been there. Now, Lord Goldsmith told us that he had only attended Cabinet conflict began to discuss Iraq, although, as you said this morning, the Cabinet discussed Iraq over 20 times. And it was clear from his evidence, I think, that he was rarely included in the other discussions you were having around this subject, and that he had relatively few face-to-face meetings with you in 2002 and the early part of 2003, particularly in 2002, to discuss this subject, which I think raised the question in our minds as to why you hadn't thought it right to include him more closely.
Well, he was very closely involved in this, in the sense that he himself, and on his own initiative actually, and after that time, we obviously had a pretty close interaction on it. At the end of July 2002, wrote to me about his legal advice. It's correct, and I think this is in accordance with tradition, he didn't attend Cabinet until we got to the point we were actually going to take the decision. But back then, we were a year off military action in March 2002. Now, had we got close to the point of military action, of course, Peter would have been very closely involved, and actually began to be involved I think it's right to say, 8 months before the military action began.
But you actually got to the point, right close to the point.
To 5 Lives coverage of the Iraq inquiry. It's Roderick Lyne putting the questions. He's talking to Tony Blair about the legality of the war, and in particular his relationship with the Attorney General.
The issue is whether he's given his advice to the Prime Minister and to the ministers, and Peter was. And just to say this about Peter Goldsmith, as you will have seen from his evidence, Peter is absolutely a lawyer's lawyer. He's someone of extraordinary integrity. He's somebody who, actually as a lawyer, is in the very top rank of the legal profession. And Peter made it quite clear from a very early stage of this that if he felt he had advice to give, he would give it. And in a sense, he would give it whether people wanted it or they didn't want it. But he was going to give it, and he did give it.